The Government of Canada is reforming Canada's copyright law, and it wants your opinion on the matter. Right now, the government is inviting public comments, holding town hall discussions and roundtable discussions on updating Canada's outdated copyright law. One idea put forward is a levy that Canadians would pay on digital media. You may not know it, but you pay about $0.25 on each blank recordable CD or blank cassette tape that you buy. That money goes towards copyright holders in exchange for their copies of private copies that you make for your own personal use. So joining me to talk about this idea, I have some guests in today at IT World Canada. We have David Baskin. He's the director of the Canadian Private Copying Collective. David Alsabrook is an intellectual property lawyer with Ludlow Law. And Justin Williams is an executive with Canadian Alliance of Students Association. Good morning, gentlemen.
Hi.
Hi. Good morning.
All right. Now, first off, all of you are participating in this government consultation in some way. I just wanted to start by collecting opinions on how you thought the process was being run by the government. Justin, maybe you can begin.
Yeah, I think the current process right now is a lot better than the original set that went forward before. Actually involving the academic community has been a major step forward, and we're really happy that members of the Canadian Alliance of Student Associations and student executives from across the country have actually been invited to go to roundtables and town hall forums. Having that voice from students who act as both creators and consumers is really enjoyed by us. Thanks.
And David, what do you think?
Well, I think it's great that it's gone from being a backroom process to a one that the general public is more aware of. And I'm impressed how quickly they were able to put together a consultative process and turn it into a whole circus across the country. I'm disappointed that the scope of it is so narrow, because there's a lot that could be done to improve just the way that the Copyright Act works in this country, instead of just bickering over who gets a few pennies this way and that. But it's a great discussion that we're having. It's a good time to have it, and I think we can make some progress.
Mm-hmm. And David?
Well, it's hardly come about overnight. It's at least a decade late. The copyright reform process has been probably the least attended to file in all of Ottawa. It has been tried and delayed many times. We didn't have any attention to copyright law paid in this country from 1924 to 1988. Phase 1 was in 1988. Phase 2 was supposed to follow imminently. It didn't happen until 1997. What was to come next was also to happen imminently, and here we are 12 years later with nothing to show for it. Various pieces of legislation have been proposed and not moved ahead with. So it's by no means an easy process. As far as the current consultation, no one has any problem with as many people as possible taking part. The difficulty is that it has been something of a dog's breakfast. What has been needed is similar to what's happened before. Publication of a white paper, a call for submission, and then organized hearings. If you knew the backstory to these consultations and roundtables, you'd be appalled at how disorganized it's been.
Interesting. Now I do want to get to the issue of private copying. So I thought that David Baskin, you could start by explaining to us this levy, since your organization is responsible for collecting it and distributing it.
Sure. Just to correct your opening remark, I am a member of the board. I'm not the director. I am a director of the company is managed by a general manager and a team. Prior to 1997, anytime a Canadian pushed down the record button on a cassette recorder, for the sake of argument, to make a mixtape for personal use or otherwise, that amounted to infringement of the copyright in the songs and the recordings that were being copied, and yet millions of copies were made. Well, obviously this is a phenomenon that is not going to go away, and that we haven't in any time tried to make go away or suggest go away. Instead, the point of the levy is to recognize the value in those copies. So in 1997, Parliament passed, in the Phase 2 legislation, a fairly wise move. They legitimized the making of copies for private personal use, not for redistribution, not for sale, but for personal use. And we're only talking about music here. This has nothing to do with anything in the way of books or photographs or films or television programs. This is exclusively songs and sound recordings of songs. They legitimized those and in turn created the opportunity for the collection of a levy on the sale of blank audio recording media. In light of that, our collective was formed. Our collective, the CPCC, represents a series of collectives who collectively represent virtually all the songwriters, music publishers, Canadian performers, and Canadian makers of recordings whose works are used in this country. And what we do is we file proposed tariffs with the Copyright Board. The board certifies those tariffs, and then we collect the levy from those who import the goods, or if any are manufactured here, that are manufactured, and then we distribute those to the people we represent. And since 2000, we've taken in something close to $230 million. We've distributed about $180 million, and the process goes on. The levy has made an enormous difference in the lives and the careers of the people who make music in this country.
Now, David and Justin, I'm wondering, first of all, do you agree with the idea that there should be a levy to make private copies? And second of all, should that levy be extended to include other forms of electronic media?
Well, I don't think there should be a levy because at the present time, the people who own the copyrights are sort of sucking and blowing at the same time. They're cashing the royalty checks, which they get whether or not somebody makes a copy of their music, and at the same time, they're putting copy protection in place so that you
So
can't
you're
make a
suggesting
copy.
there's no factual relationship between what gets used and the money that gets distributed?
Not suggesting that. What I'm suggesting is that there is a factual relationship.
But you just
that
said the people who are getting the money aren't the people whose music is being copied.
I'm saying they get paid whether or not their music is copied.
No, you're saying that there's a disconnect here. What's your basis for that?
The disconnect is that people cashing the royalty checks on the basis that they're musicians are also putting copy protection on their
How many
on their
CDs in this country have been sold with copy protection?
I have no idea.
None.
All right,
None?
Mr. Baskin, I'd like to hear Mr. Alsabrook's answer so we can address
By
some
all
of these
means.
Okay.
issues later. Thank you.
Well, there's certainly copy protection on other forms of digital media, and there's nothing presently in the Copyright Act that prohibits it. So, would it be safe to say that if the levy were to be extended to other media, such as hard drives, that you would support a prohibition on copyright locks on digital
Well, first of
software
all,
protection?
the issue of the private copying levy has nothing to do with TPMs. There are no TPMs on music sold online. There are no TPMs on CDs in this country. If there were for a brief period, it was a total market failure, and the entire music industry, or the record companies in any event, have stepped back from those. Mm-hmm. The application of TPMs to the source media has nothing to do with whether the copies are made. And in any event, there is no TPM on music being sold in this country as downloads. Mm-hmm. It's a straw man. The kind of media you're talking about, films, television programs, video games, and so on, those aren't covered by the levy, and I don't know of any proposal to include them in the levy.
Well, it's not a straw man, because if you are going to include other kinds of recording media like hard drives,
We've never suggested it should be applied to hard drives. As a matter of fact, we are on record repeatedly for the past decade as stating we have no intention to seek a levy on hard drives. That remains the case today, and I don't see any change in that.
All right, to bring in a third party here, Justin, what's your thoughts on the levy?
I'll start by saying that I honestly believe that what we need to be making sure is that the rights of the producers and the consumers are respected. And I think one of the problems with the current situation is that there's a lot of assumption about what someone does when they buy a CD, or with the proposal to include things like iPod and audio recording devices, that they're going to go out and actually take copyright material or CDs and recopy them. One of the things, I guess, coming from the sort of the youth and us making use of different technology, and especially in light of the way that this technology is now being used in the academy, is that a lot of students are using things like iPods, myself as an example, strictly for the use of taking in internet lectures and university classes. Every time I go to run, I listen to a lecture, and that's what I use my iPod for. I don't actually have music on my iPod, but that's just how I use it. But when we talk about using these levies on the purchase of things like an iPod or a disc, we're assuming that someone's going to put that music on there when they might not be. And I think that's a concern that needs to be addressed.
Would you like to
This is no different than the question of people who buy blank CDs and don't put music on it. And this is a question the Copyright Board and we have wrestled with from the beginning. Now, we survey the marketplace. We do roughly 1,000 people surveyed per month, and our surveys are a matter of public record, and they're subject to cross-examination and challenge in the hearings, so they're very professionally done. What we have found is that approximately 87 to 90% of the music that's on iPods comes from sources other than the iTunes store, which means they have been made as private copies. The vast majority of people with iPods copy music. There is non-musical use, and what the Copyright Board does in assessing the value of the levy is to factor in non-musical use, whether in the case of CDs or otherwise. Now, when the levy was introduced in 1990 on blank CDs, it was 5.1 cents. The next year it went up to 21 cents. It's since gone to 29 cents. This was driven by evidence showing the use of music, or use of blank CDs for copying music. We anticipate, it's not a secret, that the use of blank CDs for copying music is on the decline. And we fully expect that in due course the board will probably lower the levy to take this into account. If you live by the survey, you die by the survey. So we're committed to that. The fact remains, it would be an unfair invasion of people's lives and privacy to make people fess up to what they copied, and besides, it's an impossible task. We know through surveys that there's an enormous amount of private copying. You survey, you determine the value, and you impose the levy. There's no way that you could determine who is or who isn't using the levy, and it's not possible to say, even when you buy a stack of CDs at a store, how much of that you're going to use for music or not.